Here on The Flow, the morning show, and John McDonnell, who writes for us here on Flow News 24. There's an interesting case about the Northern Territory alleged stolen generations. Now, this is the case that John writes on today. It's an important one because Shine lawyers have launched class action lawsuit. This is against the Commonwealth Government, but it's on behalf of 6,000 Aboriginal Australians who were placed in institutions before the Northern Territory achieved self-government. This is back in the pre-70 era, but the Aboriginal plaintiffs are seeking damages from the Commonwealth on the basis that it owed the children and members of their family a duty of care and engaged in unlawful or false imprisonment. The court documents are filed by Shines assert that the removal regime was operated by a Commonwealth department. In other parts of the country, state governments were involved in the forcible removal of Indigenous children from their families until as recently as the 1970s. Shine lawyers are so confident of winning the class action that they have been able to persuade a litigation fund to support this particular litigation so the plaintiffs will not be forced to bear the costs. The lead plaintiff in the class action is Eileen Cummins, and she's the daughter of the Nalakakan woman and a Rembrandanga man who were born in central Arnhem Land, and she was raised in a loving and happy home. But court documents say Ms Cummins, who's now 77, was approached by a quote, Native Affairs Patrol officer in late 1948 when she was just 5 years old and asked whether she wanted to go for a ride in his car. She did not speak English, and Ms Cummins is a relative of Barbara Cummins, who was the instigator of an earlier stolen generation case. This was the Cubillo and Gunner versus Commonwealth. That case mirrors the current matter, John writes. The two children were placed in institutions, one in Alice Springs and the other in Darwin. They claim they have been removed without their parents' consent. The judge in the case found that there was no evidence that this was true. He went further and said that there was no evidence that the federal government had a general policy of removal of part Aboriginal children from their families. This judgment was confirmed on appeal by the full bench of the federal court. Now, John basically moves on and says that in these circumstances it could be cruel to hold out the hope to Aboriginal people in the Northern Territory that were in a situation of in the 70s to get compensation through litigation. Now, the Labor opposition has said that it is prepared to make ex gratia payments to children placed in institutions and that it is possible that the coalition will adopt the same policy. This is most likely the way that the claimants will receive a payout rather than via a lawyer or a litigation circumstance. And it's important to hear that the author's father was a director of welfare in the Northern Territory in the period immediately prior to self-government in order to clarify John's knowledge of this case. And this is really becomes an important discussion point. If the federal Labor and the coalition at some point in time will make ex gratia payments, it would appear that the courts are not going to uphold or change any decision that's previously been brought on the case. But yep, everyone gets their chance to have their day in court, I suppose. I guess the thing about this is the circumstances surrounding it can be very divisive, and we hope that that is not the case, because people certainly are looking to move on in their lives, and if ex gratia payments become an order of the day, then that may be the better way to finalise these matters. May drag on in courts for a long time.